Thank you again, Madam Chair. Committee members, Senate Bill 5584 concerns expanding the Office of Independent Investigations to include prosecutions of criminal conduct. For background, in 2021, the legislature established the Office of Independent Investigations, or OII, within the Office of the Governor. OII has jurisdiction to conduct investigations of incidents involving the use of deadly force by an involved officer occurring after July 1st, 2022. OII may also investigate prior incidents if new evidence is brought forth that was not included in the initial investigation. OII investigations must conclude within 120 days of commencement, and if the investigation cannot be completed in that time frame, OII must report the reasons for the delay to the OII Advisory Board. And the Advisory Board is made up of 11 members and provides input to the Governor and the Director of OII on matters including staffing, training and procedures for engagement with, procedures for engaging with individuals involved in cases. If enacted, Senate Bill 5584 would expand OII to include prosecutions of cases within the jurisdiction of the office. Under the bill, the office would have the authority to conduct prosecutions of deadly force cases, including any incident involving the use of deadly force by an involved officer against or upon a person who is either in custody or out of custody. To this end, the bill creates the position of the independent prosecutor within the office. The director of the office must appoint an attorney to fill this position within 9 months of the effective date of the act, and to qualify, the person must be admitted to practice law in Washington, have no documented criminal or disciplinary hearings involving dishonesty, discrimination, or abuses of power, and must submit to a background check and a check of the person's social media. Once appointed, the independent prosecutor would serve a term of 3 years. However, the director of the office may remove the independent prosecutor for misconduct or the inability to perform the duties of the office. The bill establishes the powers and duties of this independent prosecutor, which include final decision-making and authority related to hiring and terminating deputy independent prosecutors and support staff, filing or declining to file criminal charges, and all aspects of litigation of cases. The independent prosecutor would maintain concurrent authority with county prosecutors to investigate and prosecute use of deadly force cases by involved officers, including appeals and requests for post-conviction relief. If the independent prosecutor, a county prosecutor, and the attorney general all file competing indictments or informations charging a defendant with substantially the same offense, the court, upon a motion of the independent prosecutor or county prosecutor, must determine whose prosecution will best promote the interest of justice and prioritize the public's interest, and enter an order dismissing the information filed by the person who was not designated as the prosecuting attorney. Finally, the bill expands the membership of the advisory board by adding one additional member of the general public representing a family impacted by an incident under the jurisdiction of the office, and one additional prosecuting attorney representative. A fiscal note has been requested, and I'd be happy to answer any questions.
Thank you so much for that, Joe. I believe Senator Fortunato has a question.
Thank you, Madam Chair. So right now, this office does an investigation. They find out something. What happens? Do they turn it over to the Attorney General, and then the Attorney General then prosecute or make a determination?
Under current law, both the Attorney General and the county prosecutors have concurrent jurisdiction, so the office can refer that to either the Attorney General or the county prosecutor, who would then make that filing decision. So
if we actually enacted this bill, we would add a third layer in effect. So they would be able to prosecute themselves rather than refer it to the AG or the county prosecutors.
Yes, under the bill, it contemplates that that the independent prosecutor would have that final decision-making authority within the office to file or decline from filing charges. However, if the Attorney General's office or a county prosecutor had a different investigation into the same circumstances that led to that charge, they would still be able to file those charges independently. And then if that happens, then the court would decide which one of those prosecutions best serves the public interest and then would dismiss the others.
Okay, and that little piece, Madam Chair,
Very
that little
quickly.
piece that you just said, is that new to the bill or is that existing law?
This is, I believe, new to the bill.
Where the court would determine which one would take precedence or best serve the public.
Yes, as this new office is created under this bill, that would be new language.
Okay, thank you. Thank you, Madam Chair.
Thank you so much. Any other questions for staff? Okay, seeing none, as the bill sponsor, I'm going to be very quick about this. It's really critical to ensure that there's public trust in the criminal justice system, especially when deadly force is used by law enforcement. And we already have an Office of Independent Investigation, and what this bill does is create the position of independent prosecutor within the Office of Independent Investigation to ensure that they are doing transparent, accountable, and independent investigation and prosecution of these cases. And so I commend this bill to this committee, and I'm happy to answer any questions. Okay. Seeing none, we do have a lot of people signed in to testify. We do have the timer. It's 2 minutes. And for those individuals who we may not get to, please make sure you submit your written testimony and we will make sure everyone on the committee hears it. So with that, we have the timer starting, and we are going to start with hearing from Trishandra Pickup, followed by Kelly McConney and Debbie Novak. Tishandra, please unmute and begin.
Hello, good morning, Madam Speaker. Yes, can you hear me?
Yes, we can.
Good morning, Madam Speaker, members of the committee. I'm testifying in favor of Senate Bill 5584, the independent prosecutor. My name is Trishandra Pickup. I'm a WCPA member. I'm a Suquamish tribal member. I'm also a commissioner at the CJTC. I am here representing myself and my family. My children's father was killed by police in 2019. His name was Stonechild Chief Stick. And, prosecutor failed. That's why we're here today. And in Kitsap County, our prosecutor, Chad Enright, he wrote a letter to Attorney General at the time, Bob Ferguson, saying that he felt there was a need for an independent prosecutor and that his community here in Kitsap County don't trust the process, and also there is the need, they want that. And so we also had in the city of Paulsbo, where Stoney was killed, a prosecutor be intimidated and scared into quitting her job because she put a police officer on the Brady list. And so me personally, I feel that it's a disservice for local prosecutors to have to prosecute the police. I believe police officers and prosecutors should have a good working relationship, and they should work hand in glove. I also think that it's a conflict of interest. If we right now at the Office of Independent Investigations, they have currently cases under review. And if there isn't an independent prosecutor, they're going to go back to the prosecutors who have already denied to make charges. So for my family and many other families, we would like to have a prosecutor with fresh eyes, non-biased eyes, who do not personally know all of the police officers locally. Thank you, Senator, for I appreciate your patience.
Thank you so much. Kelly, please unmute and begin.
Thank you, Chair Dingra, committee members. My name is Kelly McConney Moore. I'm the Deputy Director of Legislation for the Policing Project at NYU School of Law, and I'm grateful to be here today to speak in support of SB 5584. We support this bill's creation of an independent prosecutor for uses of deadly force by law enforcement officers. Thanks to the past work of this committee and legislature, Washington has an Office of Independent Investigation. It helps ensure that uses of deadly force are thoroughly and independently investigated. This process helps achieve justice and fairness, as well as improves overall public safety. But even the best investigatory procedures do not guarantee accountability, which is why SB 5584 is so vital. Local prosecutors may have conflicts of interests or competing priorities that stop prosecutions in their tracks, or they may just have the appearance of a conflict. This bill creates procedures to allow concurrent jurisdiction for the Office of Independent Investigator to move forward with prosecutions. With this bill, you can ensure that meritorious cases are not neglected by local prosecutors. It will also guarantee that the public can have confidence in a fair and independent process. Creating this authority will bring Washington in line with states that provide for independent prosecutions of officer-involved killings, like Iowa, New Jersey, Hawaii, New York, and more. We thank the committee and the chair for their consideration of this important piece of legislation and urge you to recommend passage of this bill. Thank you.
Thank you so much. Debbie, go ahead and unmute. And then on deck, we are going to have Teresa Taylor, Ryan Lufkin, and James McMahon.
Good morning, Chair Dingra and committee members. Debbie Novak with the Washington Coalition for Police Accountability, and also the mother of David Novak that was shot and killed by a Spokane City police officer in 2019. David does have a submittal that has been accepted by the Office of Independent Investigation for a review. The reason for this review is due to the many errors and flaws in the investigation by the independent investigation team in Spokane, such that the lead investigator was a Spokane City detective, so he was in charge of the investigation. So David was killed by a Spokane City police officer, yet the lead investigator was a Spokane City detective. The officer that took David's life made no attempt to follow his training and did have a past and current history of insubordination. He would intentionally not follow training. He has not been held accountable in any fashion. I am asking you, please don't put the only piece of justice that is left for David back in the hands of the prosecuting attorney that has already turned a blind eye to the facts. This sends a message to other officers that this type of behavior is okay and the deaths continue. In Spokane, we have nothing when it comes to seeking criminal charges on behalf of a loved one that has had their life taken at the hands of police. History has shown this. Spokane has never pressed charges against an officer by way of the prosecuting attorney for a death. Yet we have a notorious pattern of being ranked as one of the top cities in the country for deaths at the hands of police per capita. Today, we are ranked number 3. I want to thank you, Chair Dingra, and all the committee members for all of your efforts, and please approve an Office of Independent Prosecution. Thank you.
Thank you so much. Next up is Teresa Taylor. Please unmute and begin.
Good morning, Chair Dingra and members of the committee. My name is Teresa Taylor. I am the Executive Director of the Washington Council of Police and Sheriffs. I want to take a quick moment to thank the Senate for its leadership and its support of emphasizing the importance of stakeholder work. Likewise, I want to recognize the Coalition for Police Accountability for their commitment to that work as well. It matters, and we do appreciate it. I'm here today on behalf of our 6,000 fully commissioned peace officers in our membership, and we are in opposition to Senate Bill 5584. Since 2019, the state legislature has changed almost everything about how law enforcement is deployed. We now have mandated independent investigations of all qualified uses of force by professional, uninvolved investigators. We have a statewide model use of force policy, a law mandating officers to intervene and report violations of uses of force policies. The CJTC staff now receives and investigates complaints about officers, including anonymous complaints. A reconstituted Criminal Justice Training Commission Board of Commissioners that is now a majority civilian rather than professional. An experienced expanded decertification arm of the CJTC, which now employs its own investigators. We have a state audit review after every qualifying use of force investigation to ensure laws and rules are complied with. We also have a new state agency that is tasked with the responsibility of investigating qualifying uses of force. That's in addition to the regional independent teams, and there is a lot more. The point of this summary is encourage you to stand by your work. Any bill to hire and pay a special prosecutor to exclusively focus on criminal charging decisions regarding peace officers is unnecessary, and its political nature will have an immediate cooling effect on the profession and harm public safety. It should not be ignored that in the last few years, Washington has seen 2 different use of force cases prosecuted. A new agency is not needed. Trust the reforms you've invested in. Trust the process of using currently elected prosecutors and the AG's office. Ryan Lufkin, one of our attorneys, will be more specific about the content of the bill. Thank you so much for your attention.
Thank you so much. And we're going to go to Ryan. Please unmute and begin. And James, if I can have you walk up to the front and be ready, that'll be great. Go ahead, Ryan.
Good morning, Chair and members of the committee. My name is Ryan Lufkin, and I'm testifying on behalf of the Washington Council of Police and Sheriffs in opposition to Senate Bill 5584. In my view, an unconstitutional bill that would fundamentally undermine the structure of our criminal justice system. By way of background, I am a practicing attorney, and for more than a decade, I was a prosecutor in Multnomah County. The Washington Supreme Court in State v. Rice says of the prosecutor, quote, "A prosecuting attorney's most fundamental role as both a local elected official and an executive officer is to decide whether to file criminal charges." The court said that a prosecutor needed to, quote, "reflect local values, problems, and priorities." The Washington Constitution provides for the election of prosecutors, which the court said ensured, quote, "public enforcement of criminal laws by locally elected officials," and, quote, "provided accountability to local communities." This aspect of our criminal justice system is critical. As the Supreme Court in Rice explained, quote, "separation of powers ensures that individuals are charged and punished as criminals only after a confluence of agreement among multiple governmental authorities, rather than upon the impulses of one central agency." This bill upends this carefully crafted system of justice that has endured since the foundation of our Constitution. It creates one agency that is both the police and the prosecutor, one head of both, the director, who's not elected by anyone, but rather an appointee coming from a legislatively prescribed committee. This unelected director then appoints his own prosecutor to oversee his own investigators' work. This would be like a sheriff being appointed by a committee and then that sheriff hiring their own prosecutor. Coupled on top of that is that this entity gets paid to do exactly one thing: investigate and prosecute police. Why not just have the director appoint their own judges as well and remove any final pretense to the idea that police in the state have the same rights as any other citizen? Please also keep in mind this warning. Some legislature in the future may look to this example to determine that they really need their own unelected sheriff and unelected prosecutor to do nothing but target groups you may have more sympathy toward. As a former prosecutor myself, I urge you to step back from this precipice. You may not like every decision that elected prosecutors make, but the alternative is far more terrifying. This bill may use the words independent and prosecutor, but I can assure you, having served as one, neither is true. Thank you for your time.
Thank you. James, go ahead. And on deck, we're going to have Jay Hollingsworth, Elena, and Sonia Joseph.
Good morning, Madam Chair and members of the committee. I'm James McMahon, Policy Director with the Association of Sheriffs and Police Chiefs, also here to share our opposition to this bill. The law enforcement profession is a noble one. We must acknowledge, however, that as long as we have human beings doing these jobs, we can only expect human being behavior. That includes, from time to time, criminal behavior by those that we entrust with upholding the law, police officers. Any person who violates the law, whether they're a law enforcement officer or not, should be held accountable. The perception that law enforcement officers are not routinely charged with crimes, in our mind, is not evidence that the system is broken. It's evidence that law enforcement officers don't routinely commit crimes. Locally elected prosecutors have shown and continue to show that when they believe that a law enforcement officer has violated the criminal laws of the state, they are willing and able to pursue prosecution. We saw, frankly, this summer where a law enforcement officer was charged and convicted in a jury trial of murder in the second degree. I believe it was last week that the judge imposed a 200-month sentence, well above the median range for that offense against that officer. It is our opinion, I certainly don't intend to debate the law with the chair here. It is our opinion, as you've heard already, that this is an unconstitutional delegation of authority. We think that the Snaza case, I think about a year ago, that was decided by the state Supreme Court, further enforces that belief. I'll also say in the final 30 seconds that I have, we understand the very notion behind this bill is that law enforcement and prosecutors work too closely together, and there's at least an appearance of bias there. But yet this bill places the statewide independent prosecutor co-located with the law enforcement doing the investigation there, and somehow the state is different and is perfectly capable of creating a firewall between those two that we can't do at the local level, and we question that.
Thank you so much. Jay Hollingsworth, please unmute and begin.
Yes, my name is Jay Hollingsworth. I'm a Mohican Tribal member and chair of the John T. Williams Organizing Committee. I was on the Community Police Commission for the first 6 years in Seattle, Washington, and was appointed as part of Governor's task force on this issue. We set forth a framework in OII that was an advisory to the state law, which was created after our work was completed. To me, it's inherent that the prosecutors, county prosecutors, have a bias built in towards their police officers. They need their police officers to be able to work with them willingly and openly to solve their cases and work with them. So having the independent prosecutor is just another piece of the puzzle, which we all talked about, preventing the police from policing themselves. I heard the previous speaker's comments about the firewall. I find that in my experience, the firewall was created by the union contracts with police officers, and there is the obstacle for accountability. As much as they claim they could provide accountability, I don't believe it exists in the current setup of the law and how it functions. So I am for this bill, putting the independent prosecutor in with the Office of Independent Investigations, therefore to get justice to all people involved in criminal cases. Thank you.
Thank you so much. Next up will be Eliana Machevsky, followed by Sonia Joseph.
Hi, good morning, Chair Dingra and members of the committee. My name is Eliana Machevsky, and I am testifying today in support of SB 5584 in my capacity as a staff attorney at the National Police Accountability Project. We at the National Police Accountability Project would like to thank you, Chair Dingra, for sponsoring this important bill, which would expand the Office of Independent Investigations to include an Office of the Independent Prosecutor to not only investigate, but also, when necessary, prosecute cases involving police use of lethal force. We believe that this bill is so important for maintaining accountability and fostering public trust of the criminal legal system as a whole. We do see that across the country and in Washington State, there is an inherent conflict of interest when local elected prosecutors who work closely with the local police departments as their prime witnesses in their prosecutions of civilians are asked to consider bringing charges against a police officer. There are conflicts of interest just in terms of once an officer is charged, then any of the other cases that prosecutor or the prosecutor's office might have, where they rely on that officer for testimony, are put on hold. But there's also what we see conflict of interest because across the country, elected prosecutors who have made the difficult choice and an informed choice to bring charges against police officers have faced serious backlash and threats of removal from office. And so we believe that this is such an important bill to ensure that these difficult decisions are made without any concern of conflict of interest or concern of elected backlash. Thank you so much. I appreciate you.
Thank you so much. And while Sonia unmutes, Ross Brown, please come on up to testify. Go ahead, Sonia.
Hello, Madam Chair and committee. I'm Sonia Joseph, a member of the Washington Coalition for Police Accountability. Today I'm here. Unfortunately, I have had firsthand knowledge of the tragedies that occur when law enforcement use deadly force and act above the law. It's been 7.5 years since Kent Police killed my unarmed son, Giovanni Joseph McDade. He was a 20-year-old student who was profiled, hunted, and gunned down. They violently murdered him and had no value for his life and no consequences for their actions. I'm still waiting for justice. These egregious acts take place when there is no accountability, transparency, and the public is consistently misled by law enforcement and the systems in place that protect them. In 85 years, 5 officers have been convicted for homicide in Washington state, including the most recent conviction of Officer Jeff Nelson, who was charged under the new law, Initiative 940, pushed by advocates and passed by the people. This data is alarming and has showed that it is time to establish an independent prosecutor at the governor's office. Senate Bill 5584, the independent prosecutor will be authorized to make charging decisions of homicides related to police use of deadly force. The cases will come to the prosecutors from the Office of Independent Investigations. We recognize the problem within the current system. We are committed to getting as much separation from local prosecutors as possible, and we support the proposal. And thank you, Chair Dhingra, for sponsoring. Families and communities and law enforcement need this independent look.
Thank you so much. Russ, we're going to have Ramona Brandes online and Ann Anderson. Ramona, please accept your prompt. Thank you, Russ.
Good morning, Madam Chair, members of the committee. I'm Russell Brown, the Executive Director for the Washington Association of Prosecuting Attorneys, here testifying with concerns on Senate Bill 5584. We appreciate that this version removes some of the pieces that were, to us, were very concerning, including things that called out inherent conflicts or presumptive conflicts, and did some things which we feel like would have added additional issues constitutionally to how a prosecutor acts. As you know, the Constitution provides the county prosecutor with the sole authority for criminal prosecutions of any kind of crime in their county. The Attorney General has no such jurisdiction. They can access or help prosecute cases if the governor authorizes or if a county prosecutor asks them to take a case. And a county can already appoint an attorney as a special deputy for conflict cases. And so the question is, how does this language comport with those? As we read this proposal, it gives language, it proposes to give authority for the Office of Independent Investigation and Prosecution without some of the same triggers as an Attorney General. For example, if you look at Section 1.1 and compare that with RCW 4310-232, the Attorney General's authority only comes upon the request, and that language is missing from this bill. If the intent is to give them independent authority, we think that would run afoul of the Constitution. If the intent is not to, we would suggest that you add language to make it clear that they can have, they can manage a case like a special deputy upon the request of particular entities. We also would suggest under Section 1.4 that you clarify that the governor, if they do request someone to take one of these cases, that they bear the full cost. That's something in statute now for the Attorney General. And no such procedure set up for the Office of Independent Prosecutor. And last, we would just highlight there is a case, 1937, Johnston v. Melton. That's, and I'm happy to share the case site for that. Supreme Court has cited this 3 times in the last decade, where the legislature attempted to give a sheriff-like position to county prosecutors. And the Supreme Court said, no, you just can't give away a constitutional office's core duties. And so we do think that this likely runs afoul of that. I'm out of time.
Thank you so much. Ramona, please unmute and begin. Ramona, are you, okay, go ahead.
Okay. Can you hear me now?
Yes, we can.
Okay. I don't know whether you can see me or not, but I don't think that's the important part. Thank you so much for giving me the opportunity to testify today. The Washington Defender Association and the Washington Association of Criminal Defense Lawyers, which I represent, are other on this bill. I signed in con, but our position is other. We have serious concerns about the Office of Independent Investigations taking on the Office of Independent Prosecution. Although we do support independent prosecution, housing them in the same office is going to take resources and time away from the Office of Independent Investigations. And I agree with the prosecutorial entities and the officers who indicate that they think that this would be a conflict. It is a conflict. Officers are entitled to an independent investigation and a separate independent prosecution. The Office of Independent Investigations has just started to function properly after 3.5 years. They've listed their first 2 investigations. And placing this in that office is going to be a drain on the time and the resources and derail them. In addition, we have serious concerns about the concurrent jurisdiction of the prosecutors and believe that that's going to create a morass of trouble, which will be treated different geographically depending on what jurisdiction you're in. Some jurisdictions are going to welcome the intervention of an outside agency, and other jurisdictions are going to view that hostilely as big government coming in and telling them what to do. And so people throughout the state are going to receive a different level of service in regards to the prosecution that's going to be hampered by that concurrent jurisdiction and those conflicts. So these are the concerns that we have on this bill. Thank you so much.
Thank you so much. Ann, why don't you unmute and us for the day?
Fantastic. Thank you, Madam Chair and esteemed committee members. Ann Anderson here on behalf of the Washington State Narcotics Investigators Association in opposition to 5584. We have concerns that appointing someone with the sole job of trying to find fault with law enforcement and prosecute them will further hinder recruitment efforts at a time when we're struggling to attract people to work in law enforcement in our state. This is the message that prosecution of law enforcement may continue to be politicized, which is one frequently cited factor in law enforcement choosing not to work in Washington, which, as we know, has the fewest number of officers per capita in the country. This takes power away from voters. Rather than having the prosecutor they elected to hold law enforcement and others accountable do so, this position would be appointed, diluting voter input and taking away the discretion and voice of the people. There are already mechanisms in place to hold officers accountable. Local and federal prosecutors can and do prosecute members of law enforcement when they break the law. It's common for prosecutors to call in colleagues from neighboring jurisdictions in these instances, but this is and should be at the discretion of the locally elected prosecutor's office. I recognize this is not a fiscal committee, but this is a tight budget year. with the many priorities we can't afford this session, let's not spend funds on redundancy that will further dissuade recruitment of law enforcement and disregard the choices local voters have made by removing discretionary responsibilities of their elected prosecutors. We would appreciate you joining us in our opposition. Thank you.
Thank you so much. And unfortunately, we're not going to be able to get to the last 4 testifiers. We'll have to take it offline. And with that, we're going to close public hearing on Senate Bill 5584. We have 556 people signed in pro, not testifying, and 24 signed in con, not testifying. And with that, we conclude the Law and Justice Committee for today, and we are adjourned.